16A 1369, Michael Antonio West versus the state. Mark Bennett for appellant, Maria Luke for appellee.
May proceed when ready.
May it please the court, my name is Mark Bennett, and I represent Michael Antonio West in this case, which is about the unconstitutionality of Georgia's upbraiding, insulting, or abusing a school teacher, administrator, or bus driver statute. Schools are public forums. They're places where we have PTA meetings, we have Boy Scout meetings, sometimes we vote in the gym, we have community theater, we have dance recitals. A school is not, however, an unlimited public forum. A school is a limited public forum. That is, that the school can say, people are allowed to speak here, but we're going to limit the topics on which they speak, or we're going to limit the times at which they speak. For example, Section 22-1181 forbids disrupting a school activity, so that a person cannot legally disrupt school. Section 22-1182, however, has no limits on when the speech can be forbidden. It has no limits on who is present when the speech is engaged in, other than there has to be a child hearing. It has, the limit that it has is that it discriminates against a certain viewpoint. And that is the one thing that the government cannot do in a limited public forum, is discriminate against a certain viewpoint. How does it discriminate against a certain viewpoint? Well, criticizing a school teacher, that is, upbraiding a school teacher, is forbidden, whereas complimenting a school teacher, no matter how effusively, is not. And that's the difference. It's one viewpoint is the criticism, which is forbidden, and all other viewpoints, which don't include criticism, are permitted. Because it's viewpoint discriminatory, 22-1182 fails under the First Amendment. And if the court has no questions, I'd like to reserve the balance of my time for rebuttal after we've heard from the state. Would that be okay, Chief Justice Thompson?
Look, let me ask you one question. I mean, as I read the statute, what is criminalized is the failure to depart the premises when asked to leave the premises. Now, the statute's set up in such a way that there is a speech component that may be the grounds for them to asking you to leave in the first place, but the crime itself is failing to depart the premises when you are instructed to do so, and that strikes me as kind of an ordinary criminal trespass type law.
Sure. Two things about that, Justice Blackwell. One is that the statute criminalizes continuing to abuse, insult, or upbraid the school official. That's the beginning of the statute. So it presumes, I think, that the speech continue after the instruction to depart be given. But even if that weren't the case, even if it were the case that that continue were not in there or did not mean anything, if a person insults a school teacher, administrator, or bus driver, is told to leave and does not leave, it's still a content-based restriction on speech. We have another statute which forbids criminal trespass generally. We have still another statute which forbids criminal trespass, we call it loitering, at the school. So, and those statutes cover all criminal trespass situations in a non-content-based way. A criminal trespass statute, no more than any other statute, can be justified by a content-based restriction, by requiring that someone engage in a certain sort of speech, a certain viewpoint, before the statute even kicks in. And so even if continue means nothing, the statute discriminates against a certain viewpoint, which is criticism of the teacher, the administrator, or the bus driver. Does that satisfy does that answer the question?
That does answer the question, yes.
Okay, and in fact, I think that the contrast to the loitering statute, which is criminal trespass at a school effectively, where the principal or the principal's designee can order somebody to leave the property, and if they don't leave, then they are committing a crime. In fact, they're committing a more serious crime. that covers the trespass situation with no speech component involved at all. And if that statute were used to discriminate against one sort of speech, especially against one viewpoint, then there would be there would be an as-applied challenge to the criminal trespass statute in that situation. So that, for example, if the principal or his designee says, you know what, you're not allowed to criticize my teachers, get off the property, and the person refuses to leave and is arrested for criminal trespass, then there would be an as-applied challenge because the statute, which itself is neutral, the criminal trespass statute is itself content neutral, was being used by the state in a content-based way, a content discriminatory way. So that's not the situation with 221182. 221182 has the content discrimination baked into the statute. You have to look at the viewpoint of the speaker, at the content of the speech, before the statute even begins to apply. And so if I go to my child's school and I am effusive in my praise for the teacher, to the extent that it's embarrassing and it disrupts the school proceedings, well, I can be ordered to leave the property under the criminal trespass statute by the principal or the principal's designee, but I can't be ordered to leave the property just by the teacher, unless the teacher is the principal's designee, of course. And if I'm forbidden from being on the property, if I'm ejected from the property for being disruptive, then that's not a content-based restriction on my speech. And in fact, we have another statute, which is 221181, which is disrupting a public school. So everything that the state would like to forbid with 221182 that they're permitted to forbid under the First Amendment, they forbid with other statutes. There not being any other questions, I would like to reserve the balance of my time for rebuttal and give what I can back to the court at the end.
All right, sir.
All right, thank you very much.
Thank you. Yes, ma'am.
Good afternoon. My name is Maria Luggie. I'm the solicitor for Glenn County. Basically, what brought this entire ordeal about is that the appellant feels that in some way his First Amendment rights have been curtailed because he was unable to use profanity to show his anger and to actually show out on a school bus in Glenn County. And when I was getting prepared for this case, like so many of us do, I went onto the computer and I looked up again the statute, 20-2-1182, and the information that came up showed that it actually is one of the school safety laws. And specifically, it is listed under the Georgia Emergency Management Agency and Homeland Security. And it's also located right here in Atlanta in the Public Safety Building. So the state's position is that there are times in a situation like this where the main priority here, what is the goal of this statute? And the goal of the statute is not only to educate the children, but there's an inherent responsibility to try to keep those children safe.
Well, why couldn't you have used 1181? If it was disruptive or interfered with the operation of a public school bus, or public school bus stop, you could charge them with a misdemeanor.
Yes, sir. It goes a little bit further than that because this involves an audience, specifically that the statute is not saying that you cannot insult, upbraid, or abuse a school personnel, a teacher, or a school bus driver. What they're saying is, we have an interest here, the state has an interest here, and you can't just blanketly get on there and go on a school bus or go on the school grounds and disrupt the normal function of what takes place during that day. And you've got 45 children in a classroom or on a school bus, and one irate parent gets on there.
That's not what the statute says. That's what 1181 says, that you can stop people from disrupting school operations. 1182 says if this guy had come on the bus and started screaming and, you know, this is the greatest school driver ever, and putting his arms around the school driver and saying, you know, I think you're wonderful and all these kids on the bus are the greatest, in a way that was entirely disruptive, you couldn't charge him. But if he says, this school driver stinks, you can charge him. Why is that not content-based?
Well, it's a little different because the audience, it's the children that we're most concerned about here.
That doesn't make it content-based or not content-based. Isn't the you argued the statute's just a time, place, and manner restriction, not based on content.
You're allowed to say what you want. As we all know, it's not unfettered discretion. I mean, there are certain words and language that just crosses the boundaries of being acceptable to an ordinary person. But I think with it being disruptive, it could be disruptive to anyone. This is specifically when the children are around.
But it only is when children are around and you are insulting, upbraiding, or abusing a teacher or a driver. It's not if you are complimenting, promoting, and encouraging. So it only affects your speech if it's speech that the system doesn't like, the state doesn't like. If the state apparently likes maybe complimentary disruptive statements, you can't prosecute them.
Well, if it's going to be a disruption and someone's throwing their arms up and going, you're the best teacher in the whole world, and it's disrupting that teacher's flow of what normally takes place during the day, you know, it's good for the other side also. But
Can you charge that person? Could you charge them under 1182? If they were...
Well, under 1182, it says abuse.
Okay. So you can only charge them based on the abusive content of their speech and not the positive content of their speech.
Under the statute, yes, sir.
That makes it a content-based statute, right?
To some extent, yes. The occurrence as it took place was that apparently a father's child had been spat upon by some other children a day or two before. And so the daddy decided that he was going to take matters into his own hands, and he goes to the school bus, and he gets onto the bus, and he's cussing and ranting and raving, and he's telling the children to come down. He wants them to fight his boy, and he puts out some expletives and things like that. And once the doors actually open, that's when he got on there. That's part of the school bus. It's not just actually going up into the steps. You're on the school bus when those doors open and you get on there. And the bus driver said, you can't do this. There's kids here, and you're not supposed to be on school property acting like this. She asked him to get off of the bus, and he continued on. And so the school police charged him with this code section. So the appellant goes through and he discusses the three terms: abuse, upbraid, and insult. And when I looked it up again on the internet, because he had used the dictionary, so I went online, and if we talk about abuse, you're talking about condemning, vilifying unjustly, intemperately, and angrily. Again, I understand about perhaps being complimentary, but that can also be disruptive also, and so the 1181 statute would have been more appropriate for that. But under this
what about in a very calm voice saying to the bus driver, I think you are the worst driver in the history of drivers? Is that not an insult?
I think that it's not an insult to the point of it would be disruptive to what was going on in front of those children.
Where in 1182 does it say anything about disruption or disruptive potential?
It talks about just being in the presence and hearing of the students on the premises, and they've been asked to leave. So obviously some events have taken place, and the school official, based upon their training, feels that this was not a good situation, and they try to move the person along.
But they can do that. The only reason the statute allows them to do that is because they don't like what the person said based on it being insulting or upbraiding or abusive. If the person is equally disruptive, a word that appears in 1181 but not 1182, they can't do a thing, right?
Yes.
So we just have to trust that administrators will only take it out when they feel it's disruptive, but they don't have to under the statute.
If it was not disruptive, if one bus driver is responsible for 45 children and an irate parent gets on there and he's cussing people out and telling children to come down off of there, I think the average person would think that is.
That's an as-applied argument. What about Justice Blackwell's argument? A person calmly walks up to the door of the school bus and says, "You are a terrible, terrible bus driver and I hate you." That is abusive and insulting and upbraiding. And that person could be charged if they don't immediately get off the bus.
Well, again, would an ordinary person, given the circumstances, feel that, I believe that the appellant mentions in there that they've made a statement about the football coach needs to get himself together or they're not organized enough. Well, that's an insult. I mean, anybody could consider that to be an insult, but is that enough that it would cause a problem where an average person would say, I'm going to go and I'm going to call the police at the school and I'm going to have him charged for insulting the football coach?
It's not the average person, it's you. It's your prosecutorial discretion to do it when you feel like it and not do it if you don't feel like it, based on the content of speech.
Based upon the information that they provided to us?
Not this case.
Oh.
Because this case may be bad, but you could do it if the person walks up and says you're a terrible bus driver. If you feel like it, you can indict them and then they get prosecuted.
But I'm a reasonable prosecutor also, and I don't think that it would be fair or judicial to treat someone in that manner, but...
How many overbreadth cases has this court and the U.S. Supreme Court said, we don't trust in the government being reasonable when it comes to First Amendment rights? That's the whole point of the First Amendment, is not to chill speech by having to do it and then wait and see if the prosecutor likes it or not. Are you familiar with all those cases?
Yes, sir.
How are they distinguished from what you just argued?
They're distinguished because they're not me, for one thing, and based upon the facts of this case and being concerned about the safety of the children, I feel like just being able to say you're a terrible bus driver, it would not rise to the level of having to cite someone under this statute. The main concern is about the safety of the children, and how can a bus driver who's just been threatened or yelled at continue on safely through her route and get those children there? And then to take it a step further, the dangers that we've incurred in recent years through school shootings and all, if those children don't have faith and confidence in that bus driver or that school teacher, they're not going to listen when the time comes and they say, go in that bathroom and lock the door and I'll come get you.
All of your arguments, if true, couldn't you prosecute that person under 1181 for being disruptive without any care about whether the way they're being disruptive is insulting or positive, or if they come on and just scream about how much they love their mom?
I see your point, Justice, but the thing is that there were specifically children present, and you could be disruptive without children being present. And so I feel that's why we did it under 1182. I went along with it under 1182 because of the very fact that the children were present. I think that in a circumstance, I understand about the state, but I think we have to look at what ordinary people would consider to be offensive. And some of the comments that were made are certainly not, do not rise to the level of causing anyone any emotional difficulty. It would not scare the children if they heard them saying, you know, you're a terrible football coach. I think that you need to tighten up. It doesn't have any impact. But in a situation like this, irate parent, and what about those other parents? I don't think they would appreciate one parent going on there in front of their 44 children, causing a scene, making them nervous. They've got to get to school and go through their day, and here's this one parent who's going to be a cowboy and come on there, and he had alternate means. He could have contacted the principal. He could have contacted the parents directly of the children that spat on his child. He could have gone to the Board of Education. There were other more reasonable methods that he could have done rather than going on and interfering with the course of the day on that school bus.
Has this statute, to your knowledge, ever been applied to anyone in the state of Georgia before you? It's been around for 20-something years, 26 years.
As far as I know, this is the first time.
Is this the first time anyone's ever insulted a teacher in front of students?
It depends on
I think
the,
I've done that, by the way. Could I have been charged?
if you were ranting and raving and
Not
cussing,
ranting and raving. It doesn't say anything about ranting and raving. If I insulted a school bus, actually, I know a school bus has been late, and I've complained to the school bus driver in the presence of my child, who's a student, and said, you can't keep being late. You're disrupting, our ability to get kids off to school.
I think you
That
have.
is an insult and an abuse, could be upbraiding in front of a child. But for the grace of my solicitor,
I think that that was a reasonable statement that you made, even though someone could interpret it to be somewhat of an insult. It doesn't rise to the level of being so disparaging that it would cause any disruption. This statute also, as I said, it did not limit the individual's ability to go someplace else to voice his or her complaint. It's just saying, you can take this action, take the action, but just don't do it when the children are present. I think the way that it doesn't close off their opportunity to be able to voice and use their First Amendment right to say, I think that you're not teaching my child well enough in the math area or something along those lines. But there was ample opportunity for this man to handle it in another way, and he did not have to do it in the presence of the children.
This one is unconstitutional. How do you distinguish our statute from what was found to be unconstitutional in at least 4 other states?
Yes, sir. When I read over the Florida statute, it does not allow for an alternate. It specifically says that you shall not abuse or insult the instructional staff on school property. Well, where else are you going to be able to speak to them? So that's not allowing that individual to go to the principal's office or to the teacher's room and say, I need to talk to you about this particular situation. It's saying on school property. Ours doesn't say that.
what case do you have that says a reasonable alternatives or alternative venues for speech, that gets applied to non-content-based time, place, and manner restrictions on speech? Do you have a case that says for a content-based restriction, the fact that the state will let you go say it somewhere else is sufficient to save the statute?
Not on this particular statute, no,
On
sir.
any statute?
Well-
That says, do you have a case that says a content-based restriction can be saved because the state will let you make the speech somewhere else?
I think in the Ward versus Rock Against Racism,
That was a non-content-based
Okay.
restriction. That was purely the amount of sound, very similar to the amount of sound if you, under 1181, if somebody comes on the bus and is yelling in a disruptive way, that's not content-based.
I think that the ACOC versus Police Committee, in which they were criticizing the acts of their superior officers, it's recognized as being narrower than an unlimited license to talk. We all know that there are limits on what you can say to individuals, so I think that would be applicable.
I'm sorry, I interrupted. You're going through the other 4 cases.
Koenigsberg versus the State Bar of California, 366 U.S. 36, where a municipal police department is a paramilitary organization charged with the responsibility of protecting the public. A vital public interest is involved, and to perform this duty, the employees must be governed by reasonable rules and regulations.
That's an employee speech case. Is this statute limited to the speech of school employees? It's a whole different brand of.
Yes, sir. It is limited to the school.
No, to the speech of school employees. Is it limited to only what teachers and school bus drivers say? That's a whole different branch
no.
of First Amendment law.
No, sir. Even with the ACOC case, though, it refers to it being necessary to accomplish the mission of public safety. And when it gets down to it, I think that interpreting, there are more ways. When I looked up the synonyms for the word insult, it goes beyond, and it talks about defaming. It talks about maltreatment. It talks about, it's further than just saying that you're not the best football coach here in this county. The content goes a lot further than that. The appellant also brings up about having your own child present and being able to make these statements in front of the presence of the child. And the argument with that is, again, for safety reasons and respect reasons, you're giving your child over to this teacher and this school bus driver for 8 hours out of the day. And if something takes place and that faith and that confidence in that individual school person is lost, then what about the chaos and the safety issues that come up as a matter of that? And I think it's interesting to note that it is listed under GEMA, and with the priority being safety issues. And the point being also in this particular statute that the bus driver did give the appellant the opportunity to stop what he was doing, and he continued on. And the statute says that once you've been told to stop and you continue on, that's when you can be charged with a misdemeanor. And in this particular case, Mr. West was told, you see these children are here, you're cussing, you've come on the bus, you're continuing to do so, and that's the reason why he was charged. Thank you.
Mr. Bennett, any rebuttal?
Thank you, Justice Thompson. The state's argument is essentially trust me, and Justice Namias is quite correct that neither this court's jurisprudence nor the Supreme Court's First Amendment jurisprudence allows this court to trust in the prosecutor's noblesse oblige, that we don't trust that prosecutors will narrow the statute themselves. The state talked about the facts of the case at Presiding Justice Hines's request. Since this is an as-written challenge, the facts of the case are not relevant to the challenge. The question is the statute substantially overbroad? And it is. But since the state has talked about the alleged facts of the case, I would like to tell the court that there was no cussing. I would like to tell the court that the bus driver in question was the grandmother of the children who had spat in Mr. West's son's face. So this was really more in the nature of keep your grandchildren under control and don't let them spit in my kid's face, rather than you're a bad school bus driver. It just happened that she was a school bus driver, and it happened that his opportunity to talk to the school bus driver about her control over her grandchildren who were abusing Mr. West's child happened at the school bus stop on the school bus. The state used the word threatened. There were no threats in this case, nor does the statute limit itself to threats. It doesn't limit itself to fighting words. It doesn't limit itself to disruptive activity. If you look at Tinker versus Des Moines School District, I think it is, there's a Tinker test, which is that in schools the state can restrict only that expression which materially disrupts classwork or involves substantial disorder or invasion of the rights of others. And that's 221181 is your statute that forbids disruption of school. That's the statute that passes the Tinker test. The 221182 is a content-based restriction. It restricts speech based not only on its subject matter, but more fundamentally, more crucially, on its intent, on its viewpoint. And even more crucially, it restricts people from expressing negative viewpoints about public servants. This isn't just about expressing negative viewpoints about, about the children or about, about private employees. This is about expressing negative viewpoints about public servants. And the state, if there's one thing that the state cannot restrict under the First Amendment, it is people expressing negative viewpoints about public servants. That, if nothing else were protected, that would still be protected, because that's the fundamental basis of our democracy. Because if people don't feel free to say, well, that public servant is bad, and here's why, then we have no freedom to elect the people who do better. And the basis of our democracy is that people can talk about the public servants who do badly in order to elect the public servants who do better. If there are no questions, then Mr. West prays that this court reverse the ruling of the trial court, hold the statute unconstitutional, and remand to the trial court with orders to dismiss the case. And I thank you for your kind attention. It's always nice to come to Atlanta.
Well, on behalf of the court, let me thank both sides for coming this great distance to help us with this important case. We'll get a decision to you as soon as we can. Be safe as you journey home.